Commissioner Yaki?
Yes.
Thank you.
Okay, I'm going to call us to order. This meeting of the U.S. Commission on Civil Rights comes to order at 1:02 p.m. on November 13, 2017. The meeting takes place at the Commission's headquarters, located at 1331 Pennsylvania Avenue Northwest, Washington, D.C. I'm Chair Catherine Lehman. Commissioners who are present at this meeting, in addition to me, are Commissioner Harriet, Commissioner Chladny, and Commissioner Narasaki. On the phone, if you could confirm you're on the line after I say your name. I believe we have Commissioner Yaki.
Yes.
Terrific. Commissioner Degbele.
Present.
Terrific. Commissioner Kursanow.
Here.
Terrific. Quorum of the commissioners is present. See, the court reporter is present. Is the staff director present?
I am.
Terrific. The meeting will now come to order. Is there a motion to approve the agenda for the business meeting?
So moved.
Thanks. Is there a second?
Second.
Thank you. Are there any amendments to the agenda?
Madam Chair,
Commissioner Harriet?
I would like to move to take the discussion and vote on nomination of Curtis Reed Jr. as chair of the Vermont Advisory Committee. Take that off this month's agenda, and with the suggestion it will be on next month's agenda.
Terrific. Is there a second?
I'll second.
Okay. Thank you. Any other amendments? Commissioner Narasaki?
Thank you, Madam Chair. I would like to amend the agenda for the Commission to consider a statement expressing concern about labor practices at private immigration detention centers.
Is there a second?
Second.
Any other amendments?
Madam Chair, I'd like to amend the agenda to consider for the Commission to consider a statement that supports the sentencing reform legislation currently pending in the Congress.
Thank you. Do I have a second?
Second.
Great. Are there any other amendments? Hearing none. Let's vote to approve the agenda as amended. All those in favor say aye.
Aye.
Aye. Aye.
Any opposed? Any abstentions? The motion passes unanimously. Okay, so first we will discuss and vote on the two new amended agenda items that are proposed statements. We'll begin with the statement on immigration detention centers, introduced by Commissioner Narasaki. Commissioner Narasaki, would you mind reading the statement so we know what's under consideration?
Yes, thank you, Madam Chair. The title is U.S. Commission on Civil Rights concerned with abusive labor practices at private immigration detention centers. The U.S. Commission on Civil Rights calls on the Department of Homeland Security and Congress to end abusive labor practices at corporate for-profit immigration detention centers. Private detention center providers currently are required to pay only a minimum of $1 per day to detainees who participate in a so-called voluntary work program. These corporations have a financial incentive to coerce detainees to perform necessary labor, generating higher profits for corporations who avoid paying significantly more for regular workers. The Commission calls for heightened oversight and transparency of the program and fair compensation for detainees to mitigate the growing risk of abuse. More detainees are set to enter the detention center. U.S. Immigration and Customs Service recently published notices seeking information on new privately run detention facilities that would house approximately 4,000 detainees. ICE's voluntary work program is intended to provide immigration detainees with opportunities to work and earn money. ICE's standards set detainee compensation to at least $1 per day. The program is based on a 1950 law that allows the U.S. government to pay non-citizens detained under immigration laws for work performed. Congress originally set the compensated rate to $1 per day minimum after modeling the law after the Geneva Convention's requirement that prisoners of war be paid a fair working rate of pay. For almost 70 years, the compensation has not been increased. Private detention center providers are relying on detainees to perform work required to maintain and operate detention centers, such as general cleaning, including scrubbing bathrooms, toilets, showers, and windows, washing laundry, preparing and serving meals, and maintenance, operational, barber, and library services. Private detention centers have a huge financial incentive to exploit detainee labor. In a deposition, one provider testified that if there were no voluntary workers, the provider would have to hire additional workers who would have to be paid an hourly wage to comply with its contract with ICE. A report found the provider would have spent over $125,000 in a 1-month period on wages and benefits, but instead spent $1,680 to the use of detainee labor. These incentives appear to lead to detainee abuse. Detainees at numerous facilities have alleged being forced to work under threat of solitary confinement and restraint. In one case, a detainee was allegedly punished for complaining about unsafe work conditions. In February 2017, a Colorado Federal District Court judge certified a first-of-its-kind class action lawsuit against one provider for violations of the Trafficking Victims Protection Act and unjust enrichment. Similarly, in September 2017, the state of Washington sued a provider for violating state minimum wage laws and unjust enrichment and alleged the provider sometimes paid detainees with candy and snacks instead of money. In our 2015 statutory enforcement report, With Liberty and Justice for All, the State of Civil Rights at Immigration Detention Facilities, the Commission investigated immigration detention centers, including those operated by private for-profit companies that have contracts with the federal government. The Commission found numerous detention centers failed to comply with the performance-based national detention standards, laws, and court orders meant to protect the constitutional and civil rights of detainees. Moreover, private detention centers do not have the same level of transparency as government-run centers, nor do private detention centers necessarily adopt the same standards as federally run ones. For decades, the Commission and its state advisory committees have investigated and reported on the often negative civil rights implications of our nation's immigration laws and policies. The Commission strongly urges Congress to hold a hearing to investigate labor practices at private detention centers, pass legislation requiring all detention centers to pay a fair wage for detainees, and conduct greater oversight to protect the rights of working detainees. Furthermore, the DHS Office of Inspector General should investigate alleged abusive labor practices at private detention centers, and ICE should immediately revise its 2011 PBNDS to require a fair wage for detainees participating in the work program to eliminate the incentive for labor abuses. Chair Catherine E. Lehman stated, DHS and Congress must act swiftly to correct these documented abuses in detention centers and ensure that private facilities are held to the same standard of accountability as government facilities.
Thank you. Do we have a motion to approve the statement to open the floor for discussion?
So moved.
Terrific. A second? I'll second it. Is there any discussion on the statement? Commissioner Harriet?
Yes. I intend to vote no on this statement. I have a number of objections to it, but rather than go through all of them, I will just talk about one or two here. First, I just wanted to footnote the fact that Commissioner Narasaki's very fine reading omitted the footnotes just for the purpose of the transcript, so they know that.
Another 3 hours.
Yeah, we do. I approve of omitting the footnotes. I just wanted the record to reflect that. As I said, I have a number of objections, but one of them is why does it focus just on for-profit immigration detention centers? For example, in the footnotes, we cite Guevara versus INS, a decision of the Fifth Circuit that actually dealt not with a private prison, but with a federally run immigration detention center. In particular, it dealt with Port Isabel, the one that this commission visited just a couple of years ago. I think all the issues are the same, regardless of whether or not we were talking about private prisons or federally run prisons. In our report 2 years ago on immigration detention facilities, in my statement, I talked at length about what seems to me to be a commission obsession with private prisons, that there is no evidence that private prisons are less well run or any differently run on this issue than federally run prisons. Now, that doesn't mean that Commissioner Narasaki's argument is wrong. It could be applied to federally run prisons as well. But the problem is the way this is worded, it opens us up to the criticism that we are carrying water for the prison guard unions, which is frequently, a cited criticism. And in fact, I cited it in our report on immigration detention facilities last year. As I said, Guevara versus INS is about a federally run prison. We talk about here, for example, private detention centers have a huge financial incentive to exploit detainee labor. Yes, but so do federally run prisons. The notion that only privately run prisons are interested in the bottom line, I think, is just plain wrong. And in fact, when we talked, I think, at length in our report on immigration detention centers 2 years ago, we tried to make the argument, the commission tried to make the argument over my dissent, that food service was worse at privately run prisons, when in fact the evidence went the other way. And I will refer the members of the commission to my statement in that report. As for whether this same argument should be made in the context of both private and federally run prisons, what I can say is that we definitely want to provide an opportunity for detainees to be able to earn some money while they're in detention centers. That's a good thing. It may well be that $1 a day is not a great amount for that, but that means we should be aiming this at Congress and not phrasing it as if it's a criticism of privately run detention centers. Had we said that $1 a day might be too low, yeah, it might be too low. That's something we can certainly discuss. It sounds low to me. But yes, it sounds quite low to me. Yes. However, that's not what's been drafted here. And I don't think I can sign this the way it is.
Thank you. Commissioner Narasaki?
I appreciate Commissioner Harriot's comments, and if she would join this and work with me to expand it to cover the publicly run, I'd be happy to do that. I felt that I was trying to narrow the focus because that's where the current cases, the challenges are. So it seems like, and I actually disagree. I think that for-profit entities, because they're trying to maximize profits as opposed to federally run facilities, have a little bit more incentive. Also because there is a question as to whether they are subject to FOIA laws and are as transparent, required to be as transparent as federal run detention centers. I feel that there is just a lot more room for coercion. So that's actually part of my concern. It's both the ridiculously low compensation, because I agree with Commissioner Harriot. It is good for the detainees to be given an opportunity to occupy their time and to be able to make money. But I think we agree that $1 per day or snacks is not the best way to go about it, and sort of smacks of indentured servitude. So if you would like me to work with you on this to cover public prisons, I'd be happy to delay that and rework it. I would say that the other thing is this is aimed at Congress and the Department of Homeland Security. The request is for Congress to change the law, and the request is for the Department of Homeland Security, which it actually has the power to do already, to change the regulations and require something higher than what they currently require. And also, and I want to thank Commissioner Cladney for this, it calls for the Inspector General to look at this issue to see how widespread it is.
Commissioner Harris?
I just wanted to point out, as Kevin Landry, Assistant Director for ICE's Office of Detention and Policy Planning, said about privately run detention facilities, that in fact it wasn't that privately run detention facilities have more violations of law or policy than federally run ones. He rather said that the problems with immigration detention facilities tend to be those that are dedicated to immigration detention as opposed to multi-purpose, part prison, part jail, part immigration detention center. That's where you get the problems. It's not a difference between public and private. It's a difference between centers that do population. Is it 100% immigrants, or is it partly used for convicted criminals, partly used for arrestees? So if Commissioner Narasaki would like to withdraw this draft and start from the beginning again, I might well be able to sign on to it. But it would be far more limited in the sense that I think it's an important thing that we make the ability for detainees to make some money while they're in. I think that's important to preserve that.
Well, I'm not calling for the end of the use of private detention centers. Actually, the statement does not go that far. It asks for both congressional and DHS oversight to investigate the extent of the problem. And, you know, I'd be happy to add a sentence that they should be investigating not only the privately run centers, but also the federally run centers. But if it's going to be much more limited than this, then I think I will not withdraw.
I have a hard time predicting what it would be like.
Well, you just said it.
It sounds to me like
Well, it
there's-
would be more limited, yeah. You know, the way it is now, it just picks on privately run detention facilities. And if you want to maintain the focus there, then no, I'd be against that.
No, I mean, I'd be happy to expand the focus to include the non-privately run, but
What I don't want is like something that says, you know, a couple of pages of privately run facilities, and then say, and by the way, federally run facilities too. It should focus on both equally. And that means not making a distinction. I'm with Landry that this is not where the problem is. The problem is on a different axis.
sounds to me like it. Oh, go ahead, Commissioner.
Why couldn't you just add publicly run prisons and privately run prisons wherever privately run prisons appear?
Well, private detention centers and federally run detention centers have a huge financial incentive to exploit detainee labor. I don't like the word exploit, but I got no problem with a sentence that says that. Sure, they have a financial incentive to use such labor, and the detainees have a financial incentive to participate in that. That's what makes a happy world, where you've got people on both sides of a transaction that are willing to participate.
I think one of the issues that I try to raise is, in fact, it may not be voluntary, that in fact there are reports and people have complained that in fact they're being coerced.
Just like the reports of maggot-infested food that were pretty much unsubstantiated in the previous report. You know, we have a lot of rumors that don't seem to pan out. You know, it may well be that this is the case. I have no objection to saying, you know, if this is the case, it needs to stop. I have no objection to the notion of if there are enough people complaining about this, it ought to be investigated. I'm happy to investigate it myself. I mean, as part of the commission's work. That's not a... Is that a proposal? Would you like the commission to look into that?
Why don't we pause and just see if we can hear from folks who are on the phone too. Any of the commissioners who are on the phone have discussion?
Madam Chair, Kirsten here.
Commissioner Kirsten.
Yeah, I have a question. Frankly, it's not rhetorical. It's out of curiosity. Do we know, Karen, do you know how many of these detainees participate in the program, or what percentage of those detained participate in this program?
No, that's why we would want to have the DHS Inspector General look at what's going on. But the fact that you have a court that actually ordered a class action, which is fairly rare in this kind of circumstances, I think signals that there's some serious problem.
I think a class action is ordered where there's a complaint on file and that the action affects numerous people within the system. And it doesn't say anything as to what exactly is going on or not going on. It's just certifying a class.
I think you have to show more than that, but that's okay.
So Commissioner Arasaki, do you want to withdraw or do you want to proceed? I note that the recommendations at the end include urging Congress to pass legislation requiring all detention centers to pay a fair wage for detainees. It seems like the concerns go to addressing these issues to the extent they exist at any detention center. It seems like there might be value in incorporating all in the conversation.
I'm open to the amendment of adding and how it's phrased, and federally run centers wherever we say for-profit as well.
So-
Except for where it talks about transparency, because it's just the case that, in fact, there's less transparency.
That's probably going to run into some trouble here, changing it off the cuff here without having looked at each sentence where it's mentioned. I'm happy to readdress this in December. And, if it turns out, we'll agree on at least something. And
That's always good, Gail.
yeah, I mean,
Exactly.
it could always be like, you write your statement and I agree with Commissioner Narasaki on X, Y, and Z.
Okay. I appreciate the goodwill with which that has been offered, and I will accept that offer.
Okay, thank you. So next we'll consider the statement on sentencing reform legislation. I'll first read the statement under consideration so we know what it is we're considering. And I will follow Commissioner Narasaki's convention of not reading the footnotes so that we will not be here all day. The title of the statement is U.S. Commission on Civil Rights Supports Sentencing Reform Legislation. The U.S. Commission on Civil Rights supports certain sentencing reduction provisions in the Bipartisan Sentencing Reform and Corrections Act of 2017, recently introduced in the Senate. The bill proposes to reduce mandatory minimum sentences for particular nonviolent offenses and to return discretion to judges on sentencing in more cases. It moves sentencing levels down in many cases so that low-level crimes are adequately but not excessively punished. It also makes retroactive sentencing reductions in crimes involving crack cocaine, which, prior to the enactment of the Fair Sentencing Act of 2010, were punished with extreme sentences compared with crimes involving powder cocaine. The fair administration of justice requires criminal penalties to be proportional to the offense committed, and for similar crimes to be subject to similar punishments. In addition, fair administration depends on public faith in the American justice system. This bipartisan bill takes important steps to restore the basis for that faith by addressing longstanding inequity. The Sentencing Reform and Corrections Act contains necessary and important steps towards more equitable punishments in the federal system, advancing the fair administration of justice by better fitting punishment to crime. If enacted, it would help reduce the outsized U.S. prison population without jeopardizing public safety. It stands in contrast to the change in charging policy announced by the United States Department of Justice in May. The Department of Justice policy regarding mandatory minimum sentences will result in lengthier, harsher prison sentences and additional taxpayer costs for both actual imprisonment and post-incarceration integration, unless it is changed or checked by Congress through sentencing reform. In the last 30 years, the federal prison population alone has nearly tripled. Currently, our nation has over 2 million people behind bars in state and federal prisons. Significantly, this alarming trend was propelled by criminal justice policies and not an increase in crime. The cornerstone of these policies were the harsh sentencing and mandatory minimums propagated under the so-called war on drugs. The application of harsher penalties and mandatory minimum sentences historically falls hardest on communities of color. Although facially race neutral, these policies have been applied in a racially disparate manner, raising concerns regarding legitimacy and fairness of our nation's criminal justice system. Use of mandatory minimum sentencing contributed to high incarceration rates for African American and Latino men, despite comparable rates of drug use across communities of all races. Devastating, community-wide impacts of these policies include 1 in 9 children of color having a parent in prison. National and international bodies have noted racially disparate treatment throughout the American criminal justice system, including in the application of mandatory minimum sentences. Perhaps the most notable and egregious example of the racial disparities can be found in the different mandatory minimum sentences provided for offenses involving crack versus powder cocaine. A bipartisan consensus in Congress passed the Fair Sentencing Act in 2010, reducing disparities between mandatory minimum sentences for different drugs, in part, quote, because the public had come to understand sentences embodying the 100-to-1 ratio as reflecting unjustified race-based differences. These changes should be made retroactive, as the Sentencing Reform and Corrections Act of 2017 proposes, in order to reduce excessive punishments for those already sentenced. After decades of steep growth, the federal prison population dropped when prosecutors were encouraged not to charge offenses with mandatory minimum sentences, and crime rates continue to fall. Many of the nation's prosecutors have stated their view that increases in sentencing will lead to increases in prison populations, with the attendant negative community effects, without an increase in public safety or a decrease in crime. Reductions in mandatory minimums, by contrast, allow for proportional and fair sentencing in more cases, reducing these negative effects. Chair Catherine E. Lehman said the sentencing reduction provisions in this legislation are necessary to hew closer to the fair administration of justice in our country and ensure that the criminal justice system does not more harshly judge marginalized communities without basis. I urge Congress to take swift action to correct these injustices. Before discussing the statement, I should just note also, although I said I wouldn't read the footnotes, footnote 1 identifies the specific sections of the Act that the Commission supports, and those are sections 101, 102, 103, and 105 of Title I. So now we can discuss the statement. Is there a motion so we can open the floor for discussion?
I move.
And I second. Any discussion on the statement? Commissioner Harriet?
Sorry, I'm going to vote no on this one. Though I'm happy that, given that the bill is 168 pages long, that you did quote from that footnote number 1. So we have on the record that this is not the Commission supporting the entire bill. I assume that most of us have not looked that closely at the entire bill, but rather just sections 101, 102, 103, and 105. I certainly have a lot of sympathy for the notion that crack cocaine and powder cocaine possession or sale should be punished in a way that is reasonably close. The law now does that. This is an effort to go back and retroactively apply the new law. And I want to point out, however, since there's a little bit of going back and forth in this draft, sometimes it talks about applying laws in a racially disparate manner. Sometimes it talks about racially disparate treatment. Sometimes it talks about racial disparities. I'm not sure, when we're talking about disparate treatment and when we're talking about disparate impact. But it's important for I think, people to understand that the original impetus behind the notion of punishing crack cocaine especially harshly was something that the Black Caucus and Congressman Rangel were very much in favor of. At the time, the view was that, in particular, African-American neighborhoods were being devastated by crack cocaine, and therefore the emergency required that harsh punishments come in. People have since reconsidered that, and that's fine. You can reconsider something like that. But the way it's drafted here, we're just going back and forth too much here. And I can't run on that. Another thing that bothers me about the way this is done is that it's in very conclusory language. Rather than arguing the point, it just assumes that it's right. The sentence that it moves sentencing levels down in many cases so that low-level crimes are adequately but not excessively punished. Well, what's adequate is in the eye of the beholder. And we haven't argued what's adequate here. We've just asserted that it's adequate. if enacted, it would help reduce outsized U.S. prison population without jeopardizing public safety. You know, it's a trade-off. And to just assert that, I think, is not an appropriate way to argue. The criticism of the Department of Justice's May 2017 policy, I think, is inappropriate. I think that policy is in keeping with what prosecutors are supposed to do, and that is policy gets made by Congress, and prosecutors should not be doing an end run around the policy that's set by Congress. If Congress wants to pass this bill, then they're setting the policy, and that's fine. But I think the criticism of the Department of Justice is off base. So I'm going to be voting no.
To be clear, that the different phrasing about racially disparate manner, racially disparate treatment, and racial disparities comes from citation. So the time that the statement refers to racially disparate treatment is in a sentence that says that national and international bodies have noted racially disparate treatment throughout the American criminal justice system.
But the problem is you then go and argue from that that's somehow connected to racial disparities, and suggesting to the reader that this is all of a piece, and it's not.
Well, they are connected, but the other language doesn't refer to racially disparate treatment because that's not what's being discussed in the other context. So I think that it is.
It's the same paragraph. It's the same thought, just carried on in the next sentence, and the reader can't tell what's going on when you do something like that.
Well, I think most readers understand the cite. So the cite to a racially disparate treatment is to a particular set of national and international bodies, and then the example does not use that same cite, and so it uses a different term. That is consistent with the term of art, but I appreciate that you have a set of other concerns that sentence edits sound like they won't correct, but I don't know if others have other statements.
Madam Chair, this is Commissioner Adegbile.
Commissioner Adegbile, go ahead.
Madam Chair, I think I heard I think I heard Commissioner Harriet say that the disparity had been reduced to make it reasonably close. Is it the case that the current disparity under federal law is 18-1?
Disparity between what and what?
So crack cocaine penalties used to be charged at a much heavier level than powder cocaine, and then with the bill in 2010, they were reduced under President Obama. But it's not clear to me that they're reasonably close, as you said. But maybe I'm missing something.
One of us is misinformed. If you're saying that the sentences are 18 times higher for crack cocaine than for powder cocaine after the 2010 Act, one of us is misinformed.
Okay, we can clarify.
If I could respond to a couple of points made by Commissioner Harriet. I think the bill, when it speaks about adequate sentencing, or when the statement speaks about adequate sentences, it refers to the bill itself, which reduces sentences and also allows judges a little more discretion in making sentences, as opposed to the chart that they go by now. Also, in regards to public safety, the prison population plateaued, the federal prison population plateaued in 2015, and since then crime has continued to decrease. There is also a Pew study on that as well. In addition, when it comes to policies of DOJ and criticism of that, which I think the commissioner was criticizing herself, there's an open letter from state and local prosecutors that I think is cited in the statement, saying that they believe that the policy taken by the current Department of Justice is incorrect. So, just.
Of course, it takes away some of their discretion. What a shock. What I'm saying is they should not have that discretion. That discretion is Congress's.
Right, and Congress in this bill is reducing sentences and allowing judges more discretion in sentencing. So I think the policy...
It hasn't passed yet.
I know it hasn't passed. That's the purpose of the statement.
Commissioner Arasaki?
So I just want to note, if you believe a Google search and the ACLU, that before the change, crack and powder cocaine sentencing, the difference was 100-1. And the compromise was to take it to 18-1. So it is currently 18-1.
So I would then re-put my question to see if it was the 18-1 that Commissioner Harriet was describing as reasonably close.
I'm just trying to wrap my mind around the notion of you would get 100 years at some point in the past versus 1 year. So hold on.
I think it's weight. So 18 grams of.
Yeah, well, I can't speak to that because I don't know anything about this length of cocaine.
Let that be on the record.
Yeah.
No, thank you. All right. And any further commentary about this statement? Okay. Unless there's further discussion, I'll call the question and take a roll call vote. Commissioner Degbele, how do you vote?
Aye.
Commissioner Harriet?
No.
Commissioner Kursnow?
No.
Commissioner Kladney?
Yes.
Commissioner Arasaki?
Yes.
Commissioner Yaki?
Aye.
And I vote yes. The motion passes. 2 commissioners opposed, no commissioner abstained, all others were in favor. So today's agenda gives us 2 interim advisory committee chairs to nominate. I'll begin with the Idaho Advisory Committee. I move that the commission appoint Shakira Sanders as chair of the Idaho Advisory Committee. If the motion passes, the commission will authorize the staff director to execute the appropriate paperwork for the appointment. Do I have a second for this motion?
I second.
Thank you. Any discussion? Okay. Call the question, take a roll call vote. Commissioner Degbele, how do you vote?
Aye.
Commissioner Harriet?
Aye.
Commissioner Kursnow?
Yes.
Commissioner Kladney?
Yes.
Commissioner Arasaki?
Yes.
Commissioner Yaki?
Aye.
And I vote yes. The motion passes unanimously. I now move that the commission appoint Alexis Harris as chair of the Washington Advisory Committee. If the motion passes, the commission will authorize the staff director to execute the appropriate paperwork for the appointment. Do I have a second for this motion?
Second.
Thank you. Any discussion? I'll call the question, take a roll call vote. Commissioner Degbele, how do you vote?
Aye.
Commissioner Kursnow?
Yes.
Commissioner Harriet?
Yes.
Commissioner Kladney?
Yes.
Commissioner Arasaki?
Yes.
Commissioner Yaki?
Aye.
And I vote yes. The motion passes unanimously. I'll note again that these interim appointments come to the commission after we've stood up all 51 of our advisory committees who act as our eyes and ears around the country reporting on civil rights issues. And I'm deeply grateful to our regional program staff for their continuing hard work in keeping these committees active and productive. Next, we'll hear from the staff director for the monthly staff director report.
Thank you, Madam Chair. I'll not go into any specific detail. I'm always available to answer any questions that commissioners may have about the report. I would like to mention a couple things. One, I want to commend the hard work the staff has been doing to prepare reports, hold the briefings, and prepare for today's business meeting. In particular, I want to acknowledge staff work that they've been doing to close out the fiscal year, including the finalization of our annual audit and the performance accountability report that is due this week. Lastly, Madam Chair, I want to remind commissioners to join us tomorrow at our 60th anniversary commemoration event at the Library of Congress from 1 until 3 p.m. We will hear from the Librarian of Congress, members of Congress, and from former chairs of the commission. At this time, that's all I have, Madam Chair, so I thank you very much.
Thank you.
I have a question.
Commissioner Yaki?
Yeah. What time does the program begin at the reception tomorrow?
We believe it'll start, we've planned for it to start at approximately 1:20. There'll be the Library of Congress has been kind enough to provide us with some historical documents that we'll be able to begin to look at 12:30, but we wanted to allow time for commissioners and for the public that's attending to examine the exhibits. So you can look at them starting at 12:30, but the program itself will start approximately 1:20.
Just as a student of history, I will say that I understand that exhibit will be amazing and no one should miss it.
And just so I know, because being out here, sometimes I don't get all the information about what exactly is going on. So you're telling me that we can actually be there before 1 o'clock in order to see the exhibition?
Yes, that is correct.
And what time would that period commence?
At 12:30, Michael.
In other words, when are we allowed in?
12:30, sir.
Okay, thank you.
Thank you. Commissioner Narasaki?
Yes, I just want to commend and thank the OCRE staff, especially Maureen Rudolph, Merrick, Xavier Breyer, and LaShonda Brunson for putting together a very excellent briefing book for our upcoming December briefing into the intersection of racial and disability discrimination in school discipline. There's not been, I think, sufficient attention on students of color with disabilities, and I'm very much looking forward to hearing the experts and the investigation. But I want to acknowledge staff for putting together something that has enough meat, but is not so heavy that I could actually bring it home. Thanks.
Terrific. Well, thank you all. Thank you for the report. And with that, I will adjourn this meeting at 1:43 p.m. Eastern Daylight Time. Thank you, and I hope to see you all tomorrow.
Yeah, we'll come up with something. Yeah.